Hello, ladies and gentlemen, it's Mike here at Game From Scratch, and this is the end of the epic, both literally and figuratively, lawsuit between Epic Games and Apple. And quite frankly, Apple won almost 100%, but one thing they lost, and that's going to hurt them. So this one started a long time back. In August 14th of 2020, Epic Games added the ability to buy V-Bucks, the Fortnite in-app currency, directly inside of Fortnite. And Apple immediately responded to this. So what they did, they sued Epic Games for doing so. They pulled Fortnite from the App Store. They yanked all of Epic Games' development keys, so you couldn't actually sign Unreal Engine. Obviously, that part was walked back from an earlier legal decision, so that was one thing that Epic Games won earlier on. They got their keys reinstated. That's why we have Unreal Engine 5.2 for the Mac at this point in time, because actually, at the time, Apple had pulled all of their development keys, which actually had a pretty big ramification there. Obviously, Epic Games had been intending to sue Apple all along. So they did this knowing that Apple would respond, and they launched a lawsuit. I don't think they expected Fortnite to be yanked. I don't think they expected Apple to respond as vehemently as they did, but this one has definitely been a go-for-the-throat kind of lawsuit since the very beginning. So it kind of went on, and in 2021, there was a ruling, and that ruling was primarily in Apple's favor. So this is like a TLDR summary of it. It's a law school case brief, but it kind of gives you a good overview of how that was decided. So central to the antitrust case is the appropriate determination of the relevant markets. Now, what they said, Epic Games sued them under something called the Sherman Act, and part of that is that you can't leverage a monopoly to force people to do something else. So if you say, for example, owned a monopoly on transportation, you couldn't also force those people to use your fuel. As a very bad example, I'm not a lawyer, but that's kind of the idea. You can't have these tie-ins between leveraging one product to sell another if you have a monopoly in one space. And the crux of this argument ultimately came down to is, did Apple have a monopoly? Now, Apple argued that this was in the world of gaming, and in the world of gaming, they certainly do not have a monopoly, whereas Epic says, no, you have this sole exclusive app store. You're the only way that you can sell here. That is, by definition, monopoly, and it would seem that they found that Apple was right here. So Epic Games sued Apple, alleging violations of federal and state antitrust laws and California's unfair competition law. That one's important. We'll get back to it in a minute. Upon Apple's operation of its App Store. Broadly speaking, Epic claimed that Apple is an antitrust monopolist over Apple's own system of distributing apps on Apple's own devices in the App Store and Apple's own system of collecting payments and commissions of purchases made on Apple's own devices in the App Store. Said differently, Epic Games alleged an antitrust market of one. That is, Apple's monopolistic control over its own systems relative to the App Store. Apple disputed this allegation. And then it ultimately came down to, was gaming the relevant market for antitrust purposes? And the answer was no. So, court held that the relevant market was digital mobile gaming transaction, not gaming generally, and not Apple's own internal operating system. So that's actually probably what killed Epic's case right there. So it wasn't about the App Store anymore. It was about gaming broadly, or digital mobile gaming transactions, to which they don't have exclusive a monopoly there. The court held that Epic Games failed to show that Apple was an illegal monopolist under the Sherman Act because even though it enjoyed considerable market share of over 55% and extraordinarily high profit margins, the record did not include evidence of other critical factors. The court held that Apple was engaged in anti-competitive behavior under the California's unfair competition law because of its anti-steering provisions, hid critical information from consumers, and illegally stifle consumer choice. So this one is the one thing that Apple lost on, and we'll get back to that in just a second. So this leads to yesterday and why I did this video. So that 2021 ruling was challenged. So Judge Rogers' ruling back in 2021, I think they both appealed it, to be honest. And this was ultimately, it went to the appeals court, and for the most part, Apple won all except for one case. So Apple has won its antitrust-focused appeals court battle with Fortnite maker Epic Games over its App Store's policies, according to the opinion issued today by the U.S. Ninth Circuit Court of Appeals. Court largely upheld the district's court's earlier ruling related to Epic Games' antitrust claim in favor of Apple, but it also upheld the lower court's judgment in favor of Epic under the California unfair competition law. So Epic did get a win out of this, and ironically, that win would have actually been what they were looking for to start with, but this became such a much bigger case. But So this is a recap. We already went through all the recaps, so we don't really care about that today, but we want to care more about this appeals ruling here. So appeals court panel affirmed the district court's denial of antitrust liability and its corresponding rejection of Epic's illegality defense to Apple's breach of contract counterclaim, the ruling said. It also noted that the district court had erred in defining the relevant antitrust market and holding that Apple's DPLA, or the Developer Program Licensing Agreement, fell outside of the scope of antitrust laws known as the Sherman Act. Ultimately, though, that didn't matter because that wasn't the market defined, and the existence of any substantially less restrictive alternative means for Apple to accomplish the pre-competitive justification supporting iOS walled garden ecosystem. Okay, let's do the TLDR summary. In other words, while these types of contracts can be within the scope of the Sherman Act, that wasn't relevant to the court's decision in this case. So again, it comes down to that whole argument of what the suing was over, where the monopoly was. The panel also upheld the court's ruling in favor of Epic Games within the scope of California's unfair competition law. There's another thing here that kind of hurts for Epic Games as well. The district court did not clearly err in finding that Epic was injured as a matter of law when applying California's flexible liability standards or abuse its discretion when fashioning equitable relief. That would mean the anti-steering changes the court previously decided on would once again be required. There's another part here that kind of hurts for Epic Games. Another bright spot for Apple. Appeals court ruled that the district court had erred when it ruled that Apple wasn't entitled to attorney fees related to the DPLA breach of contract claims. So at least for part of this, Epic is going to be footing the legal bills as well. But that's only like a subset of the lawsuit. Now, the interesting thing here is ultimately the one win that Epic Games did get here is that Apple can no longer force developers to use in-app purchasing. And this one is huge. If you ever used Apple back to the very beginning, they were very controlled of their walled garden. If you ever used the Kindle app, for example, Kindle used to allow you to actually go to the Amazon.com website, buy a book through a link, and Apple said, no, you can't do that. Any book you bought on the App Store got either 15 or 30%. Generally, for a big company like Amazon, it would be 15%. Now, what they're able to do is basically provide that link because of this ruling. So now you actually will be able to link out to another store. So the decision concludes the first part of the battle between the two companies over Apple's App Store policies, whether they stifle competition. Apple won 9 of 10 counts, but was found to engage in anti-competitive conduct under California law and will be forced to change its App Store's policy and loosens its grip over in-app purchases. The injunction will come into effect in December. The court concluded that Apple's anti-steering provisions hide critical information from consumers and illegally stifle consumer choice. When coupled with Apple's incipient antitrust violations, these anti-steering provisions are anti-competitive, and a nationwide remedy to eliminate those provisions is warranted. However, Roger says Apple was not monopolistic and success is not illegal. So the key thing here that's going to take away, the one thing Epic won, is ironically what they did at the very beginning. With the Fortnite, they can now actually have a link inside of the Fortnite app that would take you to the Epic Games Store where you could buy V-Bucks there. That is now something that Apple cannot prevent. So while you're not going to get an alternative app store on their hardware, which is what Epic Games really wanted, you can now link off to other payment providers other than their in-app purchases. And this is definitely a loss for Apple. It is going to hurt their bottom dollar, and this is probably one of the biggest things that Apple wanted to stop when it comes to actually earning money. So it'll be interesting to see if there is an appeal of this again. But for the most part, it does seem like this is settled and over. And on 9 out of 10 facts, Apple won. But on one of the biggest ones, basically the inability to do in-app purchases using other providers, Epic won. And at the end of the day, it does open up game developers to use alternative payment mechanisms, which is a good thing. All right, that's it. Let me know what you think. Comments down below. I'll talk to you all later. Goodbye.